Dear students, so welcome back to Industrial Property HOE 6065, and we are looking at trademarks and the directive. So I'll talk a bit more about some of these definitions, and then we'll look at Article 4 in more detail today. So how do you define a trademark? Well, definitions are very important, and as I explained previously, the whole idea of a trademark is changing so much in such radical terms. So now it's not just a word or a label or a color scheme, but even sounds and smells and the touch marks and holograms and everything under the sun. So it's a very classic legal problem. Should the law be reactive or proactive? And the most crucial part of any law would be the definition, in which we try to understand what fits within the definition of a trademark. So you have these little square boxes, and if it's a trademark, it goes here. If it's a design, it goes there. If it's a patent, it goes somewhere else. And of course, these are easier said than done. So an integral part of a trademark is that it should be capable of distinguishing the goods or services of one trademark owner from those of another. And that's basically it. So you need to understand, for example, if you're looking at smartphones, you need to have a trademark, Apple, for example, which distinguishes Apple products from rival products of rival companies, for example, Samsung. So how would this be possible? Well, it depends on the trademark itself and also how it is presented in the register of trademarks. And so this would be a classic way of dealing with this. Now, of course, the European Union Trademark Directive defines trademark under Article 3. And so if you were to look at it in detail, you will see what are the signs of which a trademark may consist. And this is a very open-ended definition in the classic legal sense. It's not a closed definition. It allows multiple sort of possibilities. And so a trademark may consist of any signs capable of being represented in particular words, including personal names or designs, letters, numerals, colors, the shape of goods or of the packaging of goods, or sounds, provided that such signs are capable of distinguishing. So that's very important. And number two, being represented on the register in a particular manner. So this is very important because what's happened here is that the previous directive had indicated that a trademark should be capable of being graphically represented, and this particular word has been removed. So it's no longer present in the legal definition. So a trademark could be any sign, and capable of being represented, particularly words, including various possibilities. And so this could be personal names, designs, letters, numerals, shape, whatever. So it's an inclusive definition, not an exclusive definition. And this is very important because what it means is in the future, if you have anything else, smell or a hologram or a three-dimensional, four-dimensional, five-dimensional, trademark, it should be allowed. So you can't just keep on amending the directive after every new type of trademark representation comes up. Instead, they have this very inclusive definition which sort of tries to cover everything. But as I explained last time, remember, as a lawyer, you try to bend the law without breaking the law. And as long as trademarks have this crazy, perpetual, forever monopoly of sorts, you keep on renewing after every 10 years, then there will always be the temptation to try to bring in sounds, or design elements, or maybe some patented aspects into a trademark regime. And this is something which the courts always have to deal with. and not very successfully sometimes. Well, in most countries now, you have specialized judges and tribunals who only exclusively deal with IP laws. And that is very important, because otherwise, most judges and lawyers may not understand the finer details or the intricacies of trademark law. So although the article doesn't really define a trademark as such, it sort of gives a guidance to member states about what signs a trademark can consist of. And so there are certain requirements. Of course, it's a directive, it's not a regulation. As I said earlier, there is also a trademark regulation which deals with community trademarks. We're not dealing with that over here. It's more or less the same like the directive, but instead we're talking about the directive. And what the directive does is it gives directions to Estonian legislature, maybe Finnish legislature, German legislature, on what are the bare necessities, the bare requirements of a trademark. Yeah. So that's out over here. So of course it has to be a sign. What could be a sign? Well, it's anything. Anything can be a sign, and it could be even a single color, multiple colors, labels, whatever. A sign could also be a representation of somebody's face. Yeah, that can be quite an issue. It's also known as character merchandising, and you put somebody's face on a package or something, and now the face becomes a trademark. It could be Mickey Mouse, could be Donald Duck, could be Donald Trump, whatever. So of course, all of these things, it could be a moving image, it could be a still image, sounds, smells, these have been around for several years already. In fact, in the Moodle course, you'll also see I've uploaded one guest lecture which was dealing with non-traditional trademarks. So that should give you an idea about just what all is covered under trademark definition nowadays. So you have conventional trademarks and then unconventional trademarks, and you have to understand why the pressure is for something different. You're trying to attract eyeballs, you're trying to attract consumers and customer attention, and consumer attention is, as limited as it can be. So you really have to focus on try to get your message across to your customer, and your customer is in the market to buy a car, and there are uh, 10, 15, 20, 30 different models of different companies available at any given time within that particular price range. And so let's say you want to buy a car for 20,000 euros, that's your budget. Well, it could cover Skoda, Hyundai, Toyota, Volkswagen, you name it. All sorts of cars are in that, Peugeot, or whatever, Renault, whatever, Ford, and so you have a choice of all sorts of products. And so now the only thing that can really clinch the deal for you is the trademark, the name. Now, this requirement for graphical representation has been done away with, because this was always a bottleneck. This was always causing a lot of problems, because there was this requirement that the trademark has to be representable in a graphic sense on the register of trademarks. And there are some examples of what a register of trademarks is. It's an official document. It has the representation of the trademark, whether it's a word or a label or whatever. Then it has the serial number. Then it has the name of the proprietor or the owner of the trademark, the address of the owner. Then it has certain classes, and we'll talk about these as well in the course of the lecture. So that's the NICE classification, and I'll explain what all of that is. And then it has the date of application, the period for which it has been used, etc. And all of these details are there in the register of trademarks. And also the register contains other information, who applied for the trademark, who owned it, who paid for the renewal, and when did they pay for it, and when was it sold to somebody else. So it's a complete register, a document as such. And now the biggest bottleneck was, how do you represent an unconventional trademark on this register? Because the previous definition required this graphical thing, that was the key. And so some of the earliest cases like Psychman, which is also in here in the Moodle case law file, dealt with this topic. And it was some German guy came up with a smell, balsamically odor of something with a whiff of cardamom or something, and that was the smell, and he applied for the trademark. And to represent it graphically, he gave the chemical formula of that particular compound, and put that up in the place where you're supposed to put a photograph or a label or whatever. And of course, the trademark office in Germany couldn't understand what the hell is this. It's just a chemical formula. And so when you read the case, you can see how obviously it was a big problem. And a lot of these problems started coming up because sound marks were already causing issues because they were overlapping with copyright law. And then came these smell marks. Some of the first smell marks to be registered were freshly cut grass, the smell of freshly cut grass for tennis balls. Yeah. And then perfumes and all sorts of things started getting applied for. And the trademark offices just didn't know how to deal with this because the law was quite strict. And so in the new directive, which was introduced about a couple of years ago, they have removed this strictness. So graphical is out, and now trademark can be anything that is capable of distinguishing and capable of being put in the register, being represented in the register. How doesn't matter anymore. So at least it's not officially dictated upon anymore. So these are the capable trademarks, and what you can do with them. There are some articles over here, but I put up this new um, guest lecture now, so it sort of covers more or less all the latest positions in this regard. All right, so you don't have to worry about this Gordon Humphrey or VK Ahuja articles. They are a bit old and dated, so I have put up some new stuff now. So capable of distinguishing is now a key element over here. What is capable of distinguishing? Now this is, in a good trademarks book, this could easily be 50-60 pages. What distinguishes X from Y? All right, it's like, let's say you have so many people who teach you. So what's the distinguishing factor between Pawan Dutt and Thomas Hoffman? Yeah, well, now this can be quite tricky, right? I mean, you could say he's German, I'm Indian. Yeah, he has a funny German accent, I have a funny Indian accent. Yeah, but maybe different styles, different ways of teaching, different ways of assessment. So this is how you distinguish between X and Y. Now, in the case of a trademark for a product, it's more difficult because you have this thing here, two pens, more or less they look identical. So how do they distinguish one from the other? Well, color, yeah, but that won't really help, right? Because the design, layout, everything looks almost the same. But one has Meresu Spa and Hotel, and the other has ABB. So obviously, these are gifts that I have picked up, pinched from wherever. So the only distinguishing factor here is just the name, nothing else, right? So when you look at these sort of things, you can already see here how this is quite problematic. And so we have Article 4, which is completely dedicated on these distinctive features and elements. So we look at them in more detail. Now, Article 4 and Article 5 deal with absolute grounds and relative grounds for refusal or invalidity. So when you read them for the first time, it would mean, okay, you apply for a trademark, there are rules. You can't just get any trademark registered however you wish to. There are certain requirements, and if you don't fulfill the requirements, then Article 4 and Article 5 will kick in, and your trademark cannot be registered. But that's only one part of it. If you read Article 4 and Article 5 and understand them properly, it will also help you later on in the infringement stages, when you go to a court of law, because the same case laws and the same provisions and principles apply. So Article 4 and Article 5 would be you apply to the trademark office and the trademark officer says yes or no. But when you look at infringement and you go to a court of law, you use the same arguments to try to justify why your rival's trademark shouldn't have been on the register of trademarks in the first place. Yeah. So there's a bit of an overlap here between the various articles. So when you read about infringement later on, maybe after 2 weeks or something, then towards the end, then you will see that the same principles are being referred to as in the beginning. So if you want to be a good trademark lawyer, just read all the stuff in the beginning. It all sort of comes back in the middle and in the end, maybe in a bit of a different wording as such. So we look at Article 4 of the Trademark Directive. Yeah, this comes under Section 2, grounds for refusal or invalidity. And these are very important foundational aspects of trademark law. Once you understand this, you are through. Now, well, maybe just to give you a bit of a background, after my law studies, I was as lost as all law students are, and I had no idea what to do. And I just applied and got rejections and stuff, whatever. And then finally, I ended up in one of these law firms, and the partner was dealing with IP law. And now, as a young law graduate, of course, nobody has big expectations from you, but you're expected to learn. And I had no idea about trademark law or patent law or anything. Yeah. I didn't even study them in the law school. These were optional subjects which I never took. And now I'm working in a law firm, young lawyer, and what the hell, what do I do here? So what I started doing was I picked up this biggest, fattest book on trademark law that they had, which happened to be this UK book. It's a Curly on Trademarks, a very good book. I still have a copy of it. In Westlaw, you can also find copies of it. Expensive book for professionals. I think these books sell for 600, 700 pounds or something. And a very good book. So I took this book and just started reading because the laws are the same all over the world, so it doesn't really matter. And I would read 20 pages from this big fat book every day. In the evening and in the morning and daytime, I would be going to the courts and doing the usual stuff, and in the office making assignment agreements or license agreements or taxation views, whatever. So do everything, and then in the evening read 20, 25 pages before going home. And well, 3 months later, yeah, you're doing practice, you're doing the theoretical parts, and it all makes perfect sense. And in all law books on trademarks, for example, the first 100, 200 pages, they cover everything, and then the same stuff sort of gets repeated in different provisions in different ways. So you get the first 200 pages properly under control, nothing can stop you. So that's my advice for you. Article 4, very important, not only from the application point of view of a trademark for registration, but also later on, because this is a very foundational aspect. So the following shall not be registered, or if registered, shall be liable to be declared invalid. Now remember, this is a law course for law students, and this is going to be very different from what I taught previously to the mixed classes. So, as lawyers, you have to consider each and every word, because all of these words are put in for a specific reason. All right. It's not like in Parliament, you just put whatever you want to put. So it's a big problem. In fact, I knew this one lawyer. He worked in Australia, Canberra, I think, yeah, and he was working in the Australian Parliament, and his job was drafting of laws. And that's a very difficult job, because there are all these pressure groups and all these different court judgments and everything. And as a lawyer, you now have to draft something which sort of is complying with all of these aspects. So similarly, if you want to work in the Estonian or the Finnish ministry, so you have a directive and there are case laws, and so you now have to also keep into account local national conditions, and based on all of that, you would then come up with a new sentence or a new paragraph or an amendment for an existing law. And because of this traditional baggage, you can't just wipe out things and put in new things. You have to be very careful, because otherwise, when this matter goes to court, the judge will ask, like, who's this donkey who is drafting all these stupid laws without applying the mind. And that can be quite a problem. So well, if you are in the European Union, you have to have a national law which complies not only with the directive and regulations, other requirements, but also with national conditions. So signs which cannot constitute a trademark, well, that's a no-brainer. Yeah, that's obvious, isn't it? What is a sign which cannot constitute a trademark? Yeah, when you start thinking about it, that's quite a tough question here, because you have conventional, you have unconventional. So, what is so apparent that it could never be a trademark? Unfortunately, that's not easy to answer, but you have to put that in anyways. Trademarks which are devoid of any distinctive character. How easy is that? How do you define distinctiveness? Nobody knows. In a good trademark book, this could be easily 50, 70 pages, and it's case law dependent, right? What is distinctive? What makes something stand out vis-a-vis others? How the hell do you do that, right? I mean, here is something. Okay, so what is this? Well, those who know, this is a little mermaid, right? Yeah, remember? Now she's sitting on a rock, and this is, something that you get in these tourist shops and things like that. Now, where was the last time you heard about this story of the mermaid and the rock? Yeah, see, it's an important city. It's an important fairy tale. It's got quite a lot of relevance. If I'm not mistaken, isn't that Copenhagen or somewhere, right? Yeah. So you see, this is very distinctive for that particular country or city. So you have to be very careful about distinctiveness. What is distinctive about Helsinki? What is distinctive about Tallinn? What's distinctive about Tallinn University of Technology? What's distinctive about Pawan? Yeah, so you say, when you try to understand these views, then you can sort of imply how this can be relevant from, say, yeah, a trademark perspective. So distinctiveness is not an easy thing to look at, but I'll try to give you some examples. There are some case laws, and when you read them in more detail, you can sort of get the answer to this. Now, what is a bad trademark? Well, that's quite easy to explain. Anything which is designating the kind, quality, quantity, intended purpose, value, geographical origin, or other characteristics of the goods or services. Now, that is a bad trademark. So, Apple as a trademark for apple juice, yeah, no, that's a horrible trademark. All right. And then there are other case laws also over there. Shemse, it's a lake in Bavaria, and so how can you say that it's a distinctive trademark? It's like I decide to open a hotel, and I call it Helsinki Hotel. Yeah, what the hell does that mean? All right, that doesn't mean anything. How can you say Helsinki Hotel? How can you monopolize that? And how can you prevent somebody else from using the trademark Helsinki hotel to airport bus transfer? Yeah. You say this cannot be a trademark because Helsinki is a geographical name. It belongs to everybody. Nobody can monopolize it. Nobody can say that no, Helsinki belongs to me, or Tallinn is my personal trademark, and nobody can use this as a trademark. So of course, you have problems here. But you have to keep in mind that this rule doesn't always exist, because about some older trademarks. Finnair, what does that imply? Finland and airlines. Yeah, so how come they are allowed to do this but not me or you? Well, you have to remember that Finnair, I think, came into being in 1929 or something. Yeah, the first flight was, I think, Helsinki to Tallinn, in the 1920s. So, they've been there before World War II, and before all these trademarks, and before the European Union and all of that. So, of course, there are exceptions in this regard. The same goes for British Airways, Air France, Alitalia. They were there before the law was drafted. So, you can't tell them to change now because now we have a new law. So the new law has to make provisions for exceptions for older cases. But generally, if any of your trademarks are in this quality quantity region, then it's not allowed. And we'll talk about these case laws so that you can understand them as well. Trademarks which have become customary in the current language or in the bona fide and established practices of the trade, yeah, they're not allowed. Now, this is a very tricky area because sometimes you can have a very good trademark, Google, and it can become, a verb. So you can start saying, come on, Google it, check it up on Google or something. So you take a perfectly good noun, a proper noun, and you turn it into a verb or an adjective or an adverb, and then that's a bad situation, because that's how these words enter the common lexicon, the jargon, and what was an exclusive trademark is now becoming a commonly used word. And when that happens, that's a very bad sign. And similarly, if there are already existing words, you can't just pick them up and use them as your own exclusive monopoly, because everybody has a right to use these words. Then signs, this is a very problematic area. Signs which consist exclusively of the shape which results from the nature of goods themselves, or the shape of goods which is necessary to obtain a technical result, the shape which gives substantial value to the goods. All of these are not allowed. So you have to be very careful here. Three-dimensional trademarks, and especially in the context of Lego. So if you look up the Lego case, you will find there was a problem. Lego, right? Everybody has seen a Lego. You play with a toy, and well, the company wanted to get the trademark for this three-dimensional shape of the brick. And of course, this is not acceptable, because if they get this trademark registered, then nobody can use that particular shape. But you see, that shape of the Lego brick is what allows it to be attached to other Lego bricks, right? So the bumps, they go into the cavities, and because it's plastic, they make a strong bond. And that's the whole idea of the shape, right? I mean, how can you divorce the structural and physical uses of that shape vis-a-vis the aesthetics part? So when we study at patents, you will understand that a shape which has a functional role, which goes in like this, it's this particular design feature, would come under patent law, and the visual aspects would come under design law, right? But not under trademark law. So this is something to keep in mind. Trademarks which are contrary to public policy or accepted principles of morality. Now, this is again a very gray zone, because what is public policy? It keeps on changing. All right. And the classic example of that is the trademark, for example, FCUK. Yeah, remember that? See, FCUK, huge problem, because they said it's French Connection, United Kingdom, and it doesn't mean anything else. But of course, that's not really the case. Maybe, well, in a classroom, I would have shown you the video, but since that's not possible, let me show you this Lego block. Yeah, remember, like this, and it has a particular shape. Keep this in mind, because this is, of course, a very good exam question all the time. And I'm surprised how even after all these lectures and all my talking, students still manage to mess it up. But yeah, you have to be careful about the shape part. Then, of course, trademarks which are deceptive, which lie, and lying is never good, and no law can allow that. So again, there are some examples. I'll talk about them so you can see from the case laws what I'm referring to. Then there are, of course, certain important trademarks which come under Paris Convention protection as such, and so these are specialized trademarks which are not allowed. Then you have also trademarks which deal with geographical indications. So that's a special thing that's come up over here. And this is because for a long time, geographical indications was left out, and this caused a lot of problems. And what are geographical indications? Well, champagne comes from France. Although there's Champansky also. This was this oddity under international law. The French and the Russians have had this love-hate relationship. Now, of course, champagne comes from the grapes that are grown in that part of Champagne. But 200 years ago, Napoleon went to Russia. It was a disaster, and ever since then, the French keep Russians like okay, keep a distance, right? So let the Russians do whatever. It's okay. After World War II, that was the same philosophy which even now the Germans adopt. Anything with Russia, they're like, okay, it's okay. Let the Russians do whatever they want to do. So Russians had Champansky, which is of course not from Champagne region of France, but that's this thing. But surprisingly now, after 200 years, the French have started to complain about this. So it's getting difficult to find Champansky products in the European Union now. But yeah, this is the then you have cognac. Cognac comes from that part of France again. Yeah, Scotch whiskey comes from that part of Scotland. Yeah, say so you can't have Scotch whiskey from Sarema. No, there of course not. You can't do that, right? You can't have cognac from Parnu. Of course not. You could have brandy because brandy is not region specific. So all cognacs are brandies, but all brandies are not cognacs. Yeah, so that's geographical indications. Then there's also this for traditional terms for wine. Yeah, again, yeah, traditional specialities. This is something that's a very regional thing. Maybe up north we don't see it this way. So in Finland, in Estonia, maybe we're not so much into all this regional stuff. But in South France, in the south of Europe, in the Mediterranean parts, this regional speciality is a big thing. So that's all covered over here. Of course, then it's also possible for a member state to make some special provisions under the law, or if there's some highly symbolic, um, you know, uh, mark, then they can say that no, you cannot have this highly symbolic mark. So, for example, in the Estonian case, you have these three lions, yeah, as a state symbol emblem, and that is a problem. In Finland, in olden times, yeah, you had this straight swastika, which was very different from the Nazi swastika or whatever. Then of course you have the other things like the Red Cross. Yeah, so this is an important symbol, and just like you have the Red Cross, you also have the Red Crescent. Yeah, so these are medical symbols, and then of course there are special provisions for this. You can't just put a flag of a country and say you're using it as a trademark, because it doesn't belong to you, it belongs to everybody. It's a national symbol, and customers may get confused when they see flag of Finland on your trademark, because they may think that you are from a Finnish government agency or something. So just like in Estonia or in Germany. So of course these are aspects as well. Then any application which is made in bad faith is not allowed. Now, what is bad faith? This is again very difficult to explain, but there are case laws on this. Bad faith would be if I approach the court with blood on my hands, then I cannot get justice. Yeah. What does that mean? Well, it's like if I am doing something to cheat you, then of course I cannot go to a court and say, hey, you are too clever and you are not letting me cheat you. Or there, of course. And then there are some specific examples of this under licensing especially, but even under trademark applications. So let's say there's a trademark Hesburger in Estonia. In Finland, it's a Finnish trademark company. But it's not there in India, right? So what if I go to India and apply for the trademark Hesburger? Yeah. And well, this would be in bad faith because number one, I'm a trademark lawyer. I should know about this international trademark. Number two, I have lived for what 13, 14 years now in this part of the world. So of course I am aware of Hesburger as a company. Number three, I know it's Finnish and I have nothing to do with Finland. So why would I apply for such a trademark in India? Well, of course, that's bad faith. Yes. So these are some of the relevant aspects. But now, as I said, there's also this provision here that just because the trademark is, not a very good or perfect trademark because of whatever was stated previously, it may still be allowed in certain circumstances because it has been used for a long time. So the use of a trademark by a proprietor can overturn the negative elements of it because this, the law is designed to help business people. It's not designed to create problems. It's designed to create solutions and easy going for businesses. So the law is not interested in messing up your life. The law just wants to protect honest business practices. So, just because the law says you cannot have geographical names, that doesn't mean that you take a 90-year-old company like Finnair and you tell them to change their trademark. Of course, that's not acceptable. So it's a very fundamental element. It's a question of fact of a lot of times. What is distinctiveness? And you have to consider the mark as a whole, but also sometimes you should also consider the background elements to it, and an overall assessment is very important over here. Over here is also important the fact that trademark law is designed to attract customers. So who's your customer base? Yeah, that's a very important aspect. Your customer is somebody with average intelligence and imperfect recollection. All right. Now, if I'm going to buy a €2 pen, I'm going to give it exactly 2 milliseconds of my attention because this is not a style statement. This is not something that will get me in the big league or anything. It's just a stupid pen. I wanted to write, works for a couple of weeks or months, and then I throw it out. €2 not worth my attention span. But on the other hand, if I'm going to buy a Lamborghini, I might be interested in a few more elements, things about it, how it works, how it looks, what is fuel consumption, what are the guarantees, what are the accessories and stuff like that. If I'm in the market to buy a Boeing 747 or whatever, an aeroplane that can, cost 200 million euros, of course, my attention span is going to be much different than when I'm going to buy this. So all of these factors have to be taken into account when you consider distinctiveness. So, of course, Mercedes is distinctive for cars. Yeah, obviously, right? But just if somebody comes up with a Mercedes shirt, yeah, a €10 cotton Mercedes shirt, would that mean it is causing a problem for the Mercedes car company? What sort of person will confuse a €50,000 product like a Mercedes car with a €10 cotton shirt called Mercedes? Yeah, you see that distinctiveness plays a big role here. It's not just about the product, but also the surrounding circumstances, the consumers, the people who the target audience is, and things like that. And along with distinctiveness, just as it is inherent, it's inside you. Ferrari, you don't have to explain it to anybody. Ferrari is Ferrari, all right? It's a fast, sexy Italian car. End of the story. But you can also acquire distinctiveness. So you may not be perfect, but you can take time and advertise and build up customer expectations and acquire a distinctive element like Tesla is doing now. Yeah, it's taking time, but it's building up this really crazy fan base. This Elon Musk, just says whatever and people lap it up. Last week he said go for bitcoins and how everybody's going crazy about bitcoins. So that's a part of the whole brand building feature. So let's stop here for today, and then I will talk about examples next week and explain things in more detail. Of course, there are some documents already which you can read in the meantime to get a better idea about everything. So thank you for your time and see you next week. Goodbye.